final case is Bill Salter Advertising versus Department of Transportation.
May it please the Court, I'm Laura Nye, and I represent the appellant, Bill Salter Advertising, Inc. I would like to reserve 2 minutes of my time for rebuttal. This is an appeal from the final order of the Secretary of Transportation adopting the Administrative Law Judge's recommended order revoking Salter's permit for a non-conforming outdoor advertising sign, which found under the Florida Administrative Code 4-10.007 that the value of new materials added to repair this sign after hurricane damage exceeded 50% of the sign's structural value and that the sign had been substantially reconfigured. Now, the basis for this appeal is that the finding was not supported by competent substantial evidence in that the findings were based primarily on photographs of the repaired sign and the testimony of one witness who testified that the materials looked new but had never seen the sign before. The only photograph of the sign prior to the hurricane in the record at R4 was blurry, taken from a distance, and did not show the configuration of the structure behind the sign faces nor the condition of those materials.
Counsel, because your time is somewhat limited, let me ask, you basically are saying that the Wayfarer case controls because that case said that the photograph alone isn't competent substantial evidence.
Correct. The Wayfarer case was somewhat similar. The signs in that case, there were two sets of photographs, some taken in 72, some taken in 77. The ones in 72 didn't show plywood extensions. The later photos did. And that was, if they had not been original to the sign, would have been in violation. The inspector who took those photographs, like the inspector in our case, was not familiar with the configuration of the sign and had no knowledge of it.
But didn't here the inspector testify about the sign where the inspector in Wayfarer relied totally on the photo?
The inspector in our case did testify about the sign. He did take the photographs of the repaired sign, but he also testified that he had never been to that site before. Therefore, he had no basis of comparison. And he also took no photographs of the back of the sign, and there were, importantly, no photographs of the back of the sign from prior to the hurricane damage. In fact, the only photograph of the sign before the hurricane damage was a very blurry photo, and you couldn't even see the support poles in it, much less the materials behind it. The only thing shown in that photo was the sign face, which, as the testimony below showed, those sign faces protect the wood from sun exposure and from discoloration.
But what is the problem with the ALJ basically accepting the testimony of Mr. White and rejecting the testimony of the witnesses on behalf of your client? Isn't that the job of the ALJ?
It is the job of the ALJ to weigh the evidence and the testimony. Our argument is that the DOT witness, as I stated, had no basis of comparison for stating that the materials were new. By contrast, the Salter representatives had been to the site.
But isn't that part of weighing the credibility of a witness that the finder of fact must undertake?
To an extent, yes. The part, though, of the ALJ's decision was based on reconfiguration of the sign, which was not shown by any photographs. The original configuration of the sign was, again, hidden by any photographs, and the DOT inspector had never seen it.
But the witness here made an inference, I suppose, that the wood looked new. And so the inference the witness made was that that was part of the reconstruction of the sign.
Well, the rule provides that, the rule is essentially based on cost of replacement materials. And that is what Salter went by in submitting documentation of the replacement or the repair. And the rule also provides that materials that are reused from the same site are not counted as part of the cost of the new materials. So the weathered condition or the coloration of the wood is problematic in making these determinations, because if a pole or some plywood had been brought from another location to this repair this sign, and it was discolored or aged, that should be, it would look like it would have been reused, but it should be counted as a new material, and the cost of that should be included under this rule. So.
But isn't that the dispute in testimony? As I see it, the witness for the DOT testified that all of this wood that appeared new leads one to the conclusion that the actual cost of the replacement exceeded 50%. And your client's witnesses said, no, all of that was wood that was there. And the ALJ accepted the testimony of the DOT's witnesses. Why isn't that competent substantial evidence?
Again, that does not go to the configuration of the sign. And also the inspector had no basis for comparison, and you can't tell how old wood is by looking at it. He had never been to the site before and did not know what the materials looked like prior.
Counsel, how much time did you want?
2 minutes.
2 minutes, okay, sorry.
Thank you. The testimony below by Salter's witnesses was that other than 3 poles and 2 sheets of plywood, all of the materials to re-erect the sign were reused materials from that sign. And the rule provides that when determining the cost of replacement materials, materials reclaimed from the site itself and repaired on site are not included. Therefore, Salter assessed the cost of replacement materials for this sign at 35% because the nature of the damage allowed them to reuse most of the materials. And Salter's witnesses testified, and it was undisputed that only 3 poles were broken.
Counsel, other than the photographs that were offered in evidence by the department, was there any other evidence offered by the department in direct conflict with the testimony of your witnesses regarding the number of poles that was replaced?
Other than the inspector's testimony that more than 3 poles looked new to him. That was the only testimony in contradiction of that. And again, it was undisputed that only 3 poles were broken. And there was also testimony that the other portion of the sign simply laid back down on the vegetation. It sheared off at a seam. And there's a photograph also in the record showing part of the sign that remained intact after the storm, and there was approximately 1/3 of the sign still erect. with no damage to those materials whatsoever.
Ms. Knight, you're well into your rebuttal time if you want to reserve some time.
I would like to, thank you.
All right.
May it please the Court, Gregory Costas, Counsel for Appalachia, Florida Department of Transportation. First point, right off the bat, I've heard a lot of conversation about the fact that the department's inspector had never seen this sign prior to its destruction. Not really an issue, simply because he was looking at the materials that were used to rebuild the sign and concluded that they were new materials. And I would submit to the Court that you would not have had to see what the sign looked like before to be able to look at the lumber that was used in there and determine that it was new lumber by its appearance.
Did he actually conclude that it was new materials, or he said the materials looked new?
He said the material appeared new to him. I mean, did he specifically say these are absolutely new materials? No, he didn't say that. He said the materials looked new. Judge Van Nortwick, the Wayfarer case is markedly distinguishable from the case here. First of all, in Wayfarer, you didn't have a finding by the fact finder that a substantial portion of the sign owner's testimony was not credible. And then secondly, the photograph that was found to be insufficient in Wayfarer was a photograph that was put in evidence for the purpose of showing what the original configuration of these signs looked like. That photograph was taken sometime after the construction of the signs, and so standing by itself, it was insufficient to demonstrate what the signs had looked for in the before condition. Here, the photographs that were admitted into evidence were consistent with the testimony of the inspector to the effect that new materials were used to rebuild the sign. So it's not like we're going back and trying to demonstrate what the original configuration of the sign looked like. He said, I was at the site, took these pictures, materials look new to me, and here's the pictures I took. So I think that takes us very much out of the Wayfarer case. Again, getting into the question I think you asked about the number of poles that were delivered to the site, I think if you look at the testimony about the delivery of the materials to the site, it probably gives you at least some small indication of why it was the ALJ came to the conclusion that the witness testimony was not credible. He testified that the only materials that were delivered to the site were the 3 poles that he delivered. No other materials could have been delivered. If that's the case, how then did the 2 sheets of plywood that they acknowledged were used, new sheets of plywood that they contend were used in the reconstruction of the sign, how did they get to the site? And there's also testimony that a concrete mix, Sakrete, was used to set the poles on site. That material doesn't even show up on the construction order, much less any testimony that that was delivered to the site. So the fact that he's saying that the only materials that got there are the ones that I delivered, and the only thing I delivered are 3 new poles, just doesn't ring true in light of the other contention that they at least used 2 new sheets of plywood. Talk about the sign face being covered with the vinyl, and that might prevent the discoloration. Well, that in and of itself still wouldn't bar a finding that new lumber had in fact been used if the ALJ believed the testimony of the department's witness. And also, if you look at the record carefully, all this testimony concerning the effect of keeping the signs covered talked about the effect of the sun on the plywood, didn't talk about general weathering conditions. Now, I would submit that if that sign face is only covered on one side, it's still exposed, wood still exposed to the elements on the other side, rain, freeze, and what have you. So general weathering was not even testified to. They just tried to hang a hat on the fact that the front part of this plywood may have been covered by this vinyl. And again, I want to touch on something that was mentioned in the reply brief that I want to clear up. Part of the explanation they came up with in the reply brief as to why this wood looked new, or would have looked new even though it was existing lumber, was the fact that there had been previous repairs to the sign. There's no record testimony about any previous repairs to this specific sign, and that issue didn't make its appearance until the reply brief. So for those reasons, I submit that that's not properly before the court. In any event, a non-issue. Let me just... And again, just to wrap it up, the bottom line is the hearing officer who observed, the administrative law judge, changed terminology on us, who heard the testimony, saw the demeanor of the witnesses, saw the evidence that was admitted of record, not only once but twice in his findings of fact, made credibility determinations where he found the evidence put on by Salter to be incredible. On that basis, the department, in preparing its final order, could not have rejected that evidence and the findings that more than 50% of the sign was new materials, and nor can this court, to the extent that it involves the revisitation of the ALJ's weight and credibility determinations. And if there are no further questions, the department would respectfully request the court to affirm. Thank you.
Thank you, Mr. Costa.
Thank you. I would just point out in a few seconds remaining that in the ALJ's recommended order, the basis for finding the testimony or any testimony that was found to be not credible was in light of and in reference to these photographs, which we submit are not competent substantial evidence to support the decision. And I believe that concludes my time. Thank you.
Okay, thank you. Thank you both. And that completes our calendar for the morning. The court will be in recess.